I thought about the discussion that we had before the lunch break, and I've decided to allow Mr. Brockler to proceed as he has suggested for a couple of reasons. One is that this video is 22 hours long. It is going to take 4 days for the jury to watch that entire video. And so that's a long time of watching the same video. Part of my job as the judge presiding over this case is to make sure that both parties get a fair trial. And inherent in that is that the jury pay attention and that the jury concentrate on the evidence. And I think it's a lot to ask of jurors to pay attention to the same video over a period of 22 hours, which would take 4 days. We usually work about 6 hours a day when you exclude the lunch break and all the other breaks we take. And so 6 hours a day would mean that we would need 4 days or 24 hours for the jury to be able to watch the video. Secondly, I have tried to allow the parties to try the case as they see fit. I've tried to the best of my ability not to interfere, because I think each party should be entitled to try its case the way it sees fit. So by way of example, I allowed the defense to use 2 attorneys during opening statements, to have 2 attorneys make opening statements. I've never done that before, but I thought in this case that made sense, given the magnitude of the case, given the type of case it is, and given the length of the trial. I felt that it made sense to allow 2 different attorneys to make opening statements. In other words, to divide the opening statements into 2 parts like that. I had never done that before, and I did it in this case. I don't know that I've ever allowed what Mr. Brockler is asking the court to allow. I may have, I just don't have a memory whether I have or not. It is true that Dr. Reed's testimony will be different than the testimony of other witnesses who have been allowed to comment about, for example, a surveillance video or some other type of video. But he's going to be commenting on his interview of the defendant. I mean, that's why I asked him to do a sanity examination. That's why he was ordered to do a sanity examination, so that he could then rely on that examination as well as on other evidence and form opinions about the defendant's sanity. So he is going to be talking about that examination and the defendant's answers. Now, he can't speculate. For example, he could not say, well, when the defendant gave that particular answer, he meant X, Y, Z. That would be improper. But he can be asked questions about why he conducted the examination the way he did, why he asked certain questions, why certain questions were important, what significance certain answers had for him, what opinions he formed based on certain answers. Those are questions that he is going to be asked by both sides. And he's going to be asked those questions whether I allow the video to play all at once or whether I allow the prosecution to play it in segments. Mr. Brockler is right that this videotaped examination was broken down into different sessions because it's so long. And I think it lasted multiple days, and within each day there were multiple sessions. There was a morning session, and then there was an afternoon session. And then, although most of the sessions took place at the Colorado Mental Health Institute at Pueblo, there was at least a follow-up session that took place later, days later, at the jail. And so it's truncated that way already as well. And so I don't see anything wrong with the prosecution proceeding in the way that it is proposing. Mr. King indicated that he may have to replay some parts of the video. And I had anticipated that already, but that's going to be the case whether the videotape plays all at once or whether it is played in segments. And so that's not going to be affected one way or another. And again, I don't see any prejudice to the defense. I don't see this as giving the prosecution an unfair advantage or any advantage for that matter. It's just a way of presenting the same evidence. And I think that they are entitled to present it however they think it is most effective. So I will allow it. And so Mr. Brockler can play a part of the videotape, then ask some questions, then move on to the next part of the videotape, ask some questions, and go on from there. But he cannot repeat, obviously, the same questions or have the doctor repeat the testimony. To the extent that anything is repetitive, I'm sure Mr. King will object, and then I will rule on any objections that are made contemporaneous with the objections being advanced. All right, anything that we need to talk about at this time before we bring the jury in? On behalf of the people? No, sir. On behalf of the defense?
Judge, just for clarification, if I'm hearing the court correctly, the court is also denying my request to cross-examine each segment one by one.
I am. I think the prosecution is entitled to do the direct examination of Dr. Reed all at once. And once the prosecution is done with direct, then you'll get a chance to cross-examine, and you can replay parts of the video and ask questions, and you can do it the same way they're doing it if you wish. So that if you want to play a certain part of the video and ask some questions, and then replay another part of the video and ask some questions, I'll let you do the same thing. But they're entitled to do the direct examination without interruption, and then you'll be entitled to do your cross-examination without interruption as well. All right, let's bring the jury in, please.